The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good morning, everyone. Please be seated. We are here today for oral argument on two separate cases. A third case is submitted at this time without oral argument, Vaccaro versus Polk County and Polk County Sheriff. That case is hereby submitted without oral argument. Our first oral argument today is State versus Patterson, and we have the Martha team here today, two Marthas. Martha Lucey, are you ready? Thank you. You may begin.
Good morning. I'm Martha Lucey. I was going to come and say I'm the good Martha, but I won't do that to Martha Trout because she's a good one too. I'm here representing Mr. Patterson. This case has several very unusual and interesting jurisdiction issues. The first one I'm going to start with is, how does a person seek review, appellate review, from an order entered in a dismissed case? This court had the opportunity to answer a similar question in State versus Mathis, and that decision was evenly split, and so there was no answer to that question yet. So a little bit of background: Mr. Patterson was charged with a failure to maintain control and serious injury by motor vehicle. The failure to maintain control, simple misdemeanor traffic ticket, was dismissed. He was sentenced on the felony, but at that time there was no amount of pecuniary damages known, or at least submitted to the district court at sentencing. 49 days later, the state sought to amend the sentence. That motion and the order included that simple misdemeanor dismissed case.
Only included on the caption, like it just included a couple numbers on the caption, or did it also make reference to the charge within the body of the order? Do you remember?
It was just on the caption, I believe.
And it probably was the old caption from when things were happening, I would assume, from the original charges before dismissal? Okay.
I'm not sure that anyone had this idea that they were entering this judgment in a dismissed case, other than that number continued to go on, and we have a judgment in a dismissed case.
We've ducked the question once. Can we duck it again, since it's the same restitution in the felony case, which we do have a way of reviewing? We can talk about what that way is, but there is a way to review it.
I'm not saying that anybody ducked any issue. Could you avoid this issue? This issue? I think the difficulty of avoiding how to seek review is that if this order remains in the dismissed simple misdemeanor, it's still a judgment. And even though the state says we're not going to
matter if, as I understand the docket entry on the NTA case, it says that the restitution order is not indexed to that case. So I know that it's cross-filed, but the docket entry from the clerk reflects that the judgment isn't entered in the NTA case.
About the docket entry on the financial side or on the public accessible EDMS?
The publicly accessible docket says that the judgment is not entered in the NTA case. I think it calls it the monetary piece or something like that.
And I don't recall that, Your Honor. If that's what it says, maybe it's not docketed there. But the victim in this case can seek execution of a judgment independent of the state. So 910.7a, I believe it is, allows the person who suffered pecuniary damages to seek execution on a judgment.
Get one satisfaction of the judgment, and if they can collect under the felony count in full, we can review the felony count, affirm or adjust or reverse. Does it matter that this misdemeanor is hanging out there.
So far as if this court reverses the order in the felony count, it still remains.
Isn't the issue in Mathis, though, still present here? So if I recall right, in Mathis, the issue was the assessment of costs in exchange for dismissal of the charge in that case. And I can't remember what it was in Mathis. But the NTA case here, the simple misdemeanor, there's still an assessment of court costs for a dismissed case in that case. So isn't that the same illegal sentence question that was presented in Mathis?
But different because of the procedural position this case was in.
It's different because there was no conviction of a crime in Mathis, right? There was just a deal to pay costs, right? That's my recollection of it.
I did follow.
And just, you've got costs allocated to, you know, a dismissed case as well as a non-dismissed case.
Mr. Patterson was ordered to pay costs in the simple traffic ticket, but that was entered at the time of the dismissal. The restitution judgment was entered after the dismissal was done.
Should have been dumped on that day. We've got two different orders here at issue. The first one was the actual, let me find it here. The supplementary sentencing is the order that's really at issue, because the one before that, which would have been just the sentencing order, it had to include the NTA number because that was the document that said NTA is hereby dismissed. So that one's okay. Would you agree? It's the next one that actually sets the victim pecuniary damage at $42,000 and includes that NTA number.
It again on the April 13th order, which is the subject of the appeal.
If I were, right, I've got that one too. And if there, as Justice Mansfield said, if there was no felony out there, I would wholeheartedly agree with you. There's a big fat judgment out there stapled to a misdemeanor, a simple misdemeanor. But that's not reality here. Is this really, do we really have, are you making a bigger deal out of something than really is there?
Because if the felony judgment goes away, we still have a simple misdemeanor judgment. And even if the clerk didn't docket it, the court ordered it.
Well, maybe. So I think there's a difference between a case or cases that are consolidated into one case number, which frequently happens in the district court. We do it here as well, versus this situation where for administrative ease, you have two separate cases where one order is cross-filed between two distinct cases. So if the district court interpreted this order to only apply to the felony case, then there really is no judgment entered that could be executed on in the district court, at least as I read the docket. That I would think as a district court judge, if somebody tried to execute on a judgment in the NTA case, I would say there is no judgment here other than the cost judgment. I mean, does that distinction make sense to you? And if it does, what is your response?
I understand the distinction that you're making, but I think the difficulty is that when we say it's cross-filed, well, in order to be filed on EDMS, it has to have that number. But what's the purpose of including that number on this judgment? Is it a mistake? Maybe, but the district court has entered this order. It didn't specify, I'm only talking about the felony.
For a nunc-pro-tunc, we never use those up here, but I loved those in the district court. Why not a nunc-pro-tunc? Isn't this just kind of a Scrivener's error?
To my knowledge, he never did, but he wouldn't have been represented by counsel in district court as soon as the notice of appeal was filed. He doesn't have counsel in district court.
Right now?
You can fix it however you want to fix it.
5 years.
Seriously, if you can fix it and just eliminate it, then there isn't this question. And then hopefully maybe with some mention in an opinion, practitioners in district court and judges in district court may go, oh, I can't do that.
brief remand during the appellate process for them to take a peek at it, and then we'll look at it again?
However it can get fixed, I'm perfectly willing for that, because ultimately, for Mr. Patterson, he just doesn't want this judgment hanging out in this simple misdemeanor, which, if he was convicted of, isn't authorized. Chapter 910 doesn't apply to traffic tickets under 321, and it certainly doesn't apply to a dismissed case. But, however,
Isn't that, though, what your point about 321, isn't that the simplest answer on this? And that's what the state says as well?
simple answer, but then the question is what is the form of review to get there? And I still think that it is a writ of certiorari just because of the procedural posture this case is in. But I can also see where it could be an application for discretionary review, similar to Stessman, which was the restitution in a deferred judgment case. I think it's certiorari for a couple of reasons. When I briefed this case, and actually when I did the amicus in Mathis, I looked at it as the authority or the power, jurisdiction, subject matter jurisdiction to enter a restitution order. And I think that there's maybe that class of case is not the correct class to look at. I think maybe it's the power to enter an order in a dismissal. Or the subject, I'm getting my words confused, subject matter jurisdiction for a dismissal, to enter an order in a dismissed case. But if you look at it as authority, that's where the 321 comes in, that Chapter 910 does not apply to simple misdemeanor traffics. So that would be the lack of authority, where you would then look at it similar to an illegal sentence. I think any of those routes can work, but I think that practitioners need to have some guidance on what form should they be filing. Because I think, as everybody knows, it's really easy just to file that notice of appeal, and then the court has to figure out, or appellate counsel has to figure out, what should this proper form be. So I would urge you to actually say, what is the form? And then if you want to wipe it out however you want to wipe it out, I'm fine with that.
Do you want to spend some time on the merits? Because I suspect what we've been talking about matters a whole lot to those of us in this room, but to your client, maybe the judgment, the amount of the judgment is what matters. So,
is there substantial evidence to support that $34,000 plus in lost wages? So lost wage earners, what is their damages? It's generally what their hourly rate is. Mr. Tidwell was not working at the time of the accident. He had stopped working for A1 Concrete in November. The accident was in February. He may or may not have been working on contract for detailing trucks, I believe the testimony was. We don't know what that hourly rate was. Can you use the hourly rate or the amount from 2019 when that is not where he is working anymore? There's no evidence that he would have been working there, that the availability of jobs through the union hall. You know, what kind of jobs? Yeah, he said up to $26 an hour. Up to, what does that mean? Estimation in some speculation is acceptable under case law, but that's usually for calculations that are hard to make. Such as the patent cases or trademark cases. Here we have an amount. What is that amount that this individual would take home? And he wasn't working. He had told them he wasn't coming back. Is that substantial evidence?
Maybe after the incident he had a realization or a decision. I mean, before he chose not to work, apparently. But after this incident, for a period of time, he could not work because of your client's conduct.
And I don't think there's a dispute that he could not necessarily do the work that he had been doing, but he had not looked for any other work.
Paul, he was a seasonal concrete worker, and he had worked for the same company for several years, and he said, I'm not working for them anymore, but I'm going to go to the union hall and I'll work for somebody else. That's what he said his plan was. And so the trial court awarded him basically the wages he had gotten annually, historically, as a concrete worker for this other company. That seems reasonable to me, isn't it?
Well, insofar as we don't know that that's what he would have been doing. So seasonal layoff came in November, and he told his former boss he wasn't coming back. And so he didn't get unemployment, and he went to work detailing trucks. I see that my time is up. May I conclude? Yes, please do. So that 2019 income is very speculative as to what 2020 would have been. And they didn't present evidence of what 2020 would have been because he wasn't at A1 anymore. I would ask this court to reverse the judgment and determine the forms of review for both of these interesting questions.
Counsel, on the review of the merits of the restitution order, you briefed a pathway to notice of appeal, direct appeal, and also talked about a pathway to certiorari. But both of those pathways lead us to reading substantial evidence review.
Correct.
Essentially. So long as there's substantial evidence review, there's no constitutional problem in this case.
That's a hard question because I think the difficulty is that if it's not a right of appeal, then it's always subject to only some discretionary grant through the writ of cert. People who are sued in civil court for tort damage, just like what criminal restitution is supposed to be, they have a right of appeal. So there is that question of if it's not a right of appeal, is there a constitutional problem? In this case, you can grant certiorari and give Mr. Patterson his review, but that doesn't mean that there's not a constitutional problem. And maybe on rebuttal, we can talk about what to make of 910.7.5. Thank you very much.
Thank you.
May it please the court, I'm Martha Trout for the state. The defendant's argument relative to the appeal and the simple misdemeanor that was dismissed in this case elevates form over substance. The defendant does not enjoy a right to appeal a simple misdemeanor. That means is through discretionary review, which would not be appropriate in this case for many reasons. Number one, this was an agreed upon term of the plea agreement that the defendant agreed to pay the costs associated with the dismissed appeal. And by happenstance, if you will, once the case continued after the sentence, so the OWOM, the NTA were put on the judgment and sentence, and then following those restitution challenges, the NTA number was also included. If you were to look at the financial section under Iowa Courts Online, the NTA does not include any amount for pecuniary damages, nor could it. The state agrees that you cannot seek pecuniary damages for a violation of 321. We did not ask for it in that case. We are not requesting it. The district court clerk did not assess those amounts. So to the extent there is a judgment, it is a judgment for the fine and the costs, of which only $10 for court costs is outstanding. So the question is, well, how does this defendant who seeks to appeal from the dismissed simple misdemeanor affect some type of appellate review? Well, it would either be through discretionary review or through a petition for writ of certiorari. And discretionary review is not appropriate in this case because it doesn't present a matter that is of importance to the bench and bar, because the defendant cannot demonstrate that he is essentially on the line for the $34,000 in the simple misdemeanor case. He certainly is under terms of the OW, or the serious injury by vehicle. So discretionary review is not possible. The last opportunity would be a petition for writ of cert if, in fact, the court acted in some way illegally. And we have cases from the Court of Appeals, State versus Abbasi, State versus Teelbein, that find that in a particular circumstance where the costs associated with a dismissed case are illegal, then the defendant may be able to piggyback on those types of cases. But those cases are unique in that there was no plea agreement in either of those cases. This situation
resolve the illegality of the imposition of costs.
Well, Your Honor, it's not, first of all, we would not assert that this is an illegal act. When the defendant agreed to the terms of the plea agreement, he agreed that he would pay court costs in exchange for the dismissal of the NTA and the 2 additional charges in the OWOM.
Authorizes that.
It's not a statute, Your Honor. What we have talked about or what the court has found in State versus Petrie and State versus McMurray is that an encouraged plea agreements to, you can negotiate for these types of agreements, a bargain for consideration, if you will, so that those cases would be.
There was an agreement, and the agreement was you're going to pay $10 to my favorite local charity. Okay? That's part of the plea agreement as part of the dismissal of costs. Is that legal?
Allowed under the statute to pay to the favorite charity or whatever. I believe it would be under the under 910. It would be local anti-crime organizations. It's limited under 910 to what those types of things can do.
The plea agreement authorizes this. The statute says costs can only be imposed where there is a plea of guilty, a verdict of guilty, a special verdict upon which a judgment of conviction is rendered. There's no judgment of conviction in the NTA case, correct?
Well, but it's a plea. It's a plea of guilty to
conviction. It's dismissed.
That judgment of conviction is dismissed. I agree with that, but it's under the terms of the plea agreement. So what you're saying is if we take your argument to the logical conclusion, then plea agreements relative to dismissed cases, which under Petrie and under McMurray, you'd have to have an asterisk relative to the language in those cases.
Isn't there a distinction between a dismissed case and a dismissed count and a multi-count trial information? That's what Petrie and McMurray were about, is that you can assess costs associated with dismissed counts as long as there is a judgment in the case. The NTA case, there is no judgment. If there were a judgment, the defendant would have an appeal as a matter of right. So the state's taking the position that there's no judgment, so he can't appeal, but there is a judgment for the purposes of restitution. That seems very inconsistent to me.
The defendant does not have a right to appeal the simple misdemeanor. That's State versus Jones. He does not. Right. And these types of cases routinely, especially with regard to a felony or a simple misdemeanor, I think to the defendant, it is a bargained for consideration, so that he, to the extent that he would agree that he is going to not suffer the consequences of an additional count, an additional claim, that he can do this as a part of the whole, the entirety of a criminal action. Like
on the favorite charity example, you said he can't agree to that. because it's not authorized by statute. So where is the statute that authorizes the imposition of costs in the absence of a judgment of conviction?
I would point you to, I still interpret McMurray and Petrie as saying that you can work out these plea agreements, and that as part of this plea agreement that we will agree to that dismissed cost.
Did Petrie go to restitution though?
Costs. Right.
What case goes to restitution?
I believe it was McMurray. I believe McMurray talked about the restitution. That was my understanding, is that was part of it relative to restitution. And routinely, I mean, the criminal justice system works and is fed by a multitude of plea agreements. And that's how we are able to dispose of these cases, to offer incentives and to allow for the defendants to have, and more often than not, a benefit to a bargain. As the Chief Justice pointed out, the appropriate means in this case to reconcile any error that occurred, and we believe it is essentially a form, would be for the defendant to seek a nunc pro tunc in this case, and to have that NTA number removed from from any of the decisions or the sentencing order that postdates the judgment and sentence from December of 20. Now, moving on to the issues with regard to whether or not what type of review is this defendant entitled to, the state submits that under the new provisions of Iowa Code Chapter 910.3, that the means to review this case is through a writ of certiorari, and that the statute contemplates a particular circumstance that occurred in this case. So the defendant was entered a guilty plea. District Court entered a judgment and sentence in December of 2020. At that time, the District Court informed the defendant that he was going to have to pay pecuniary damages to the victim. The amount was not known at the time. In February, the state filed its request. The District Court the District Court ordered that amount roughly.
Respond to the defendant's argument that he had a right to be present at that sentencing in February.
Your Honor, I don't, the right to be at the sentencing in February? Oh. He doesn't, it's not necessarily a sentence. It was a request for pecuniary damages, and then the court ordered that the imposition, then he objected, and then obtained a hearing on that in April. So I don't necessarily consider that to be a sentencing hearing that he was entitled to be present at. Under the statute, he can challenge what the district court's order, that supplemental or subsequent order with regard to restitution. So he has rights under the statute. He exercised those rights, even had counsel. And then, and so any problems with due process, the defendant was afforded his rights, provided what the legislature provided under the statute. I don't believe that there is, that leads into the question as to, what type of process that he is entitled to. This defendant was given all of the process that he had the notice of the change in the restitution amount. He was given, he objected to that. He was given the opportunity to be heard and was heard, and he also had counsel for that.
I read the defendant's constitutional argument as touching on the process below, but really ultimately aimed at whether or not there's a right to appeal versus the certiorari review. Would you address that?
Yes, Your Honor. After several years of changes to restitution and what is the appropriate means or method, the legislature in June of 2020, the current iteration of Chapter 910 went into effect. And the court was the legislature was very specific as to the means by which a criminal defendant is able to challenge restitution. If restitution is included in the original judgment and sentence, the defendant has a right to appeal. That is clearly stated in 910.3, I believe sub 8. If, however, that amount or there is a subsequent order for restitution and the defendant requests a hearing, the means by which to challenge that is through certiorari, and that is under 910.7 sub 5. It still gives a defendant an opportunity for review. Yes, it is limited, but the statute can be read essentially now as requiring an exhaustion of remedies, that the defendant must seek a challenge in the district court before any type of appellate review would be available. So in this instance, appellate review is through certiorari.
And I was asking your co-counsel or your opposing counsel about the question of harm. I mean, if we ultimately move on to a substantial evidence review, which is what is being asked for either way under a direct appeal or certiorari, what's your stance on whether there'd be some harm either way?
I think that I don't believe that there is any harm when you review the record in this case and you look at what type of evidence the state put on and what the W-2 forms, the witness's testimony, that there is substantial evidence to establish that there is a causal connection between the amount of restitution sought, and in this case it's for lost wages, and the offender's criminal activities. To the extent that, I'm sorry.
Let me put it a little differently. Do you think that our substantial evidence review in a direct appeal should be different than our substantial evidence review if we treat this as certiorari?
I don't believe so, Your Honor. I think that it is, we're reviewing this restitution challenges for correction of errors at law. And so to the extent that did the district court err as a matter of law in assessing this, I would think that the review would be the same. And to backtrack a little, when under the court's rules and the rules of appellate procedure, should a defendant seek to challenge something and they seek review under a notice of appeal, but it's more appropriately for a cert, the court gives the defendant or the litigant the benefit of the doubt in determining which one it is to consider. And this defendant has had the opportunity in this instance to get before the Supreme Court and make these allegations. So I would think that this defendant has...
Substantial evidence that supports this restitution award.
It is the testimony from the witness himself and in combination with the W-2. I remind the court that in State versus Edouard, restitution challenges or restitution hearings need not comport with all of the rules of evidence, mainly because we're past the fact of an adjudication of guilt, or I see my time is running, if I may briefly conclude. And so I think that when you look at the testimony of the victim, in this case, Mr. Tidwell, and you look at what his testimony was relative to how hard he worked, how much he worked. He had been in construction for 30 years, had constantly been employed, did a lot of work, and so that in combination with his inability to work as a result of the accident would be sufficient, as this district court found.
A windfall for are we double counting the unemployment award or that component?
Really, he did not apply for unemployment. As I said in my brief, he did admit that he acknowledged that he did receive $6,000 from crime victims, which could be deemed a windfall. And in my brief, I acknowledged that you could subtract the $6,000 from that because that could essentially be a double recovery. But it should be roughly, I believe it is maybe $28,000 would be the amount. So the state requests that this court dismiss the request for review under the simple misdemeanor, find that the appropriate means of review in this instance is a writ of certiorari, and affirm the district court.
While you're walking up, I'll ask you your first question just to hopefully put a bow on that issue that I think actually the issue of the NTA, I'm shocked it got to this level. It really seemed like a situation that wouldn't. But your opposing counsel stated that if you look at Iowa Courts Online, there's nothing under there. And isn't that what is used to show whether or not there's a judgment against someone? So if there's a zero balance or not even a column for pecuniary damages, where's the harm? Where's the foul?
The harm is going to be if it is reversed and vacated in the felony, then there still is this order in the NTA, and the clerk can put it in.
Which is dismissed because something else happens in another case, are they?
You look at, I think it's 602.14, somewhere in there, the duties of the district court. The judge doesn't tell the clerk to go ahead and enter that judgment. The clerk does it themselves. So because there is this order, there's nothing that stops anyone from saying, okay, now it's no longer in the felony, it needs to go into the simple. Because if it's going to be, oftentimes, cost judgments are going to be added to one case versus split to both. If one goes away, there's still the requirement that it be in the other one.
I recognize that we like to try to solve problems, but the theoretical future enforcement in the misdemeanor feels theoretical to me because the state is making it clear that 321 didn't authorize it. They say in their brief that they don't even think that there's something to fight about there at all. And so I wonder if we should save those future conflicts that you're concerned about for another case.
And I understand your position, but what it is that if he doesn't challenge it now, how is he ever going to challenge it if it were to happen? His timeline's gone.
Has agreed that the 6,000 comes off. So if we enter an order, or if part of our opinion remands for a reduction in the amount in the felony, what's going to happen to the NTA judgment, if anything?
If the new judgment gets filed in both cases, then it's still there.
Reduced amount.
If it gets filed in both cases, then there is still a judgment in both cases. The court could say, you can't enter the judgment in the simple dismissed, do a non-proton, fix that, fix the one in the felony, and then it's gone. But the difficulty of saying, possible things in the future is that when that happens, what's your remedy?
By the way,
To have a funeral till there's been a death.
Unless
Seek review, could your client seek review at that point when there's a live controversy?
not, because the judgment's been entered a long time ago. If there's a new judgment entered and it would qualify as an illegal sentence and all of those questions that I'm asking you to decide, then maybe, but then again, maybe not.
Wait, the state doesn't represent Mr. Tidwell, and I'm not sure I agree that the $6,000 should come off. I thought he testified that he had gotten unemployment during the winter in the previous year because he's seasonally employed, but didn't get it in 2020. And he also, and that's why the trial judge didn't deduct the $6,000. So why can't we leave that the way it is?
As presented was he did not get unemployment in November, December of 2019 or January of 2020 because he was not intending to return to work.
He also testified, I thought, that in 2019 he got some 1099 work as well. Obviously, he wouldn't have got that. He was very seriously hurt in this accident. And there's no dispute about that.
That he was injured. And in 2019, the testimony was he did get unemployment because I think the winter of 2019 and probably the late 2018, because he was working for A1. But his intent was to go work for the union hall, which is not, that's a temporary position. There's not an employer. So you're not entitled to unemployment if you don't have an employer that counts. I see that my time is up. I would ask that this court vacate the judgment or at least remand for deduction of the $6,000 and correction or vacation of the order in the simple misdemeanor. Thank you.
The case of State versus Patterson is hereby submitted, and we'll have a brief transition to the next case, Alvarez Victoriano versus City of Waterloo.